Well, hello and good morning. Welcome to another uh, morning coffee with Dr. Childress here. So, today I'm going to be discussing what's at the core of the family courts and what's happening here. It's two constructs, established constructs, called institutional betrayal trauma and regulatory capture. And what's happened is the forensic custody evaluation industry has gotten up into an institutional capture of the family courts. And so, in one particular domain, the family courts is controlled by this group of psychologists who are experimenting on human subjects without IRB approval and everything. And they've got this new quasi judicial role they made up for themselves and a new assessment procedure of a forensic custody evaluation. Both of those are experiments. The quasi judicial role advising the court on custody, that's an experimental role for doctors. And the custody evaluation method that they've come up for that role is an experimental assessment procedure. What we do as doctors traditionally is diagnose and treat. But they're not diagnosing and they're not treating. They're doing something different. They're experimenting on human subjects, a vulnerable population. That's extremely bad. And what they've done is called institutional capture. And so they're withholding diagnoses and offering only their custody evaluation, and there's no oversight or review. That's the regulatory capture part of things, that there's no oversight or no review. And what it does is it produces this feature or this trauma called institutional betrayal trauma. The institutions that should protect the, the public and the person instead become instruments of abuse. And the classic example is a sex abuse in the Catholic Church. That's in the cover up of that. That's institutional betrayal trauma. So that's exactly what's happening in the family courts. The institutions, APA, licensing boards, that should be protecting people are actually protecting the unethical psychologists who are abusing the people in this culture of abuse that's going on in the family courts. So that's what I'll be talking about today, and it's actually it's actually a textbook case. What's going on in the family courts is a textbook case of institutional betrayal trauma and regulatory capture. So I have a feeling this is going to be spoken about for like 40 years after I'm dead, just because it's a textbook case of these features, and that people will be looking at how was it allowed to happen, because it's devastating what the consequences have been. So first, let's talk about what institutional betrayal is. And so the primary source for that is Jennifer Freyd, out at the University of Oregon. Her key article is with Smith, The Dangerous Safe Havens, Institutional Betrayal Exacerbates Sexual Trauma, in the Journal of Traumatic Stress. The definition of betrayal or institutional betrayal is it occurs when an institution fails to protect those who depend on it, responds inadequately to reports of harm, or actively enables or perpetuates harm. So that's what's happening in the family courts, the institutions. The defining article is Smith and Freud, Institutional Betrayal, from the American Psychologist. Now, the American Psychologist is the Journal of the American Psychological Association. So let me stop here and talk about that. This is the Journal of the American Psychological Association. Okay, so that's how firmly rooted this concept is. So it's institutional betrayal in the American Psychologist. The core concept is that this article formally defined and established the empirical investigation of the concept. It describes how institutions like universities, military, churches, or corporations have the potential to worsen post-traumatic outcomes through their actions or inactions. And so all you parents out there who are suffering because you've lost your kid, institutional betrayal trauma, all you now adult children who are suffering and kind of disorganized in your lives and figuring things out, that's post-traumatic stress. That's institutional betrayal. So the examples: acts of omission and commission. Omission would be failing to implement effective prevention policies, or not warning members about known risks perpetrators. That's happening here. They're not. There's no IRB. There's no risk benefit analysis. There's no protections for vulnerable population when they're allowed to experiment on people for their own financial benefit. And then acts of commission are creating policies that discourage reporting, and that's here, quasi-judicial immunity and the release requirements that discourage reporting, actively retaliating against whistleblowers, okay, here, and or covering up wrongdoing to protect the institution's reputation. And so the covering up wrongdoing is, I've got 6 licensing boards complaints out against 6 at the top forensic custody evaluators from a class I took from them. So I've now put them in a position where they either have to sanction the top forensic custody evaluators for 2.01, 2.04, 9.01, and 3.04 for ethical violations. It's a cascade. But basically for 2.01, they're not competent based on their education, training, and experience and attachment, and delusional thought disorders and family systems, complex trauma, a lot of stuff they're not competent in. 2.01 violation. And so that's going to put them in a position where they either cover it up or expose it. The moment they expose it, and with any sort of sanctions, then the whole system collapses because those are the top, and what about everybody underneath? So it's that's going to be occurring because I've already set that trigger into place. Now, so here's some quotes from Freyd from 2013. Institutional betrayal occurs when institutions people depend upon for safety and well-being fail to protect them or engage in actions that harm them. That's from the Journal of Traumatic Stress. Now, in Freyd 2014, institutional betrayal includes acts of omission and commission by the institutions that betray the trust of those dependent upon that institution. And that's absolutely occurring. And let me just say, we got one evidence of that. In 2018, I hand-delivered a petition signed by 19,000 parents that detailed the ethical violations in the family courts and requested some remedies. And I described the pathology. I described in detail what the ethical violations are. 2018, it's never had a response, 0 response. I've got a website up with a little counter waiting for the APA to respond to 19,000 parents and a psychologist describing in detail the ethical violations in the family courts. That's by omission, institutional betrayal by omission here. So then the third quote from Freyd is that institutions often respond to reports of wrongdoing in ways that silence the victims, protect the institution's reputation, and perpetuate harm. So that's where this is coming to a head in the California Board of Psychology issues that are going to be coming to a head at the end of December here. 3 days of hearing is that I am a whistleblower that is exposing the unethical practices and the cover-up of child abuse. Okay, it's not parental alienation. Everybody needs to understand that. It is not parental alienation. There is no such thing. The actual term is child abuse. Okay, it's child psychological abuse. It's a DSM-5 TR is shared persecutory delusion, factitious disorder. It's child abuse. So we need to be talking about child abuse in the family courts, not parental alienation. That needs to go away because it covers up the problem. And I've got huge amounts of evidence regarding that. So, they're they're trying to silence the whistleblower, sanction the ethical psychologist who's been here for 15 years under 1.05 to take further action when there's ethical violations and duty to protect. And they're trying to sanction me in favor of the self-proclaimed PAS experts that are covering up the child abuse with this made-up fabricated pathology label, and won't stop, and won't use the DSM-5. If they use the DSM-5, it's a shared delusion, it's child abuse. Boom, boom, boom. And it immediately gets solved in the family courts because there's an assessment for a delusional thought disorder. It's called a mental status exam of thought and perception. So as soon as you apply the DSM-5, everything gets solved, the child gets protected, everything, but they're not doing it, nor are the custody evaluators. And so that's your institutional capture and institutional betrayal. Trauma on you is the fact that nobody is relying on the DSM-5 for their decisions. And we're doctors, we're psychologists. That's everywhere else we do. ADHD, schizophrenia, autism, everywhere else we rely on the DSM-5, except in the family courts. In the family courts, you're allowed to make up new roles, quasi-judicial role for doctors of advising the court on custody. You're allowed to make up new assessment procedures, forensic custody evaluations, and you're allowed to make up new forms of pathology. Parental alienation, parent-child contact problems, resist, refuse. You're just allowed to make things up for you. A specific class of people somehow don't get the same quality of services that everybody else gets. Institutional capture, institutional betrayal trauma, and regulatory capture. So the antidote, now here's interesting. And so here's the antidote proposed by Freud to institutional betrayal trauma. It's institutional courage. And you can think about this when, like, the Penn State sex abuse scandal or the Catholic Church sex abuse scandal. What do you do when the institution encounters the betrayal and the capture? Do they try to cover it up, or do they come clean on it and do the right thing? And that's coming clean on it and doing the right thing is called institutional courage. And it was coined by Freud as a solution to institutional betrayal. Institutional courage is the positive, proactive, and ethical response that institutions can adopt. So in the family courts, that would be immediately you stop forensic custody evaluations. Immediately. They're experimental. They've failed. New York Blue Ribbon Commission. They are dangerous. They are harmful. They have no IRB, no risk-benefit analysis, no special protections. They are dangerous, harmful to children, lack scientific and legal value, all from the New York Blue Ribbon Commission. The one regulatory idea that finally came to the family courts was through the legislature of a state, New York. The legislative system said, what's going on in the family courts? We're getting a lot of the pain from these people. What's happening? Well, let's appoint a blue ribbon commission to look into forensic custody evaluations. What do they find? Dangerous, harmful to children, lack scientific and legal value, lead to potentially disastrous consequences for parents and children, quote unquote. And they voted 11-9 to eliminate forensic custody evaluations entirely. And nobody voted that they were a good thing. All of them, the 9 who voted to keep them, was because there's nothing else. And they would rather have something than nothing. The 11 who voted to eliminate would rather have no mental health services in the family courts than what they're currently receiving. That is an abomination for the court. Professional psychology has an obligation to provide the court with high quality mental health information for its decision making. And when we have the New York Blue Ribbon Commission saying we would rather have no mental health services than what we're getting, what kind of quality mental health services are we providing to the courts? Not to mention the child abuse that's here. Shared delusion, factitious disorder. It's child abuse, and we need to get over it. It's an abomination of what's happening here. And so the institutional courage is the institution's commitment to seek the truth and engage in moral action despite unpleasantness, risk, and short-term cost. That's where we stand right now with the APA, with the licensing boards, with the AFCC. Are they going to try to cover things up and the institutional betrayal, or are they going to seek the truth and engage in moral action despite the unpleasantness, risk, and short-term cost? It is a pledge to protect and care for those who depend on the institution and is oriented toward the common good. That's exactly where we sit at this point in 2025. We'll see what happens as we go into 2026. So institutional betrayal, the relevance to forensic psychology in this case with the California Board of Psychology is psychologists reporting harm, standard 1.04 and 1.05, depend on the professional institutions to receive the report and act. When APA, AFCC, or forensic oversight bodies dismiss legitimate ethical concerns, fail to correct evaluator misconduct, or shift scrutiny onto the reporting psychologist, this matches Freud's framework precisely. Okay, and so this is going to be studied for 40 years. Institutional betrayal is the pattern in this case. Shows failure to protect children and parents. I'll repeat that because that's important. Failure to protect children and parents. Failure to act on ethical warnings. Procedural silencing of the whistleblower and institutional preservation over public protection. This is a textbook institutional betrayal as defined in the trauma literature. Okay, textbook. So let's talk now about regulatory capture. The primary source for that is George Stigler. He's a Nobel Prize winner in economics. The key article is Stigler, The Theory of Economic Regulation, Bell Journal of Economics and Management Service. The definition is regulatory capture occurs when the regulatory agency becomes dominated by the industry it is supposed to regulate. The forensic custody evaluators are on the boards, they're in the field. And so the regulatory agencies of the licensing boards have been captured by the ones they're supposed to regulate. They prioritize the interests of the regulated professionals over the interests of the public. And that's exactly what we got here. So Stigler, as a rule, regulation is acquired by the industry and is designed and operated primarily for its benefit. So the industry gets the regulation and then starts to benefit from the regulation. Regulation is not directed at the protection of the public, but at the protection of the regulated industry. And regulatory capture is the process by which regulated professionals exercise undue influence over the very institutions intended to oversee them, resulting in the erosion of accountability and public protection. Okay. So let me just briefly stop here to highlight so far where we are. We have Freud with institutional betrayal trauma. We got Stigler with with regulatory capture. Okay, these are established constructs. Freud, American psychologist, that's the APA journal, and Stigler, a Nobel Prize winner in economics. These are known things. Okay. The relevance to forensic psychology in this case is that the AFCC's model standards for forensic custody evaluation, such as Standard 4.6C, suppress diagnostic competence. Let's see again. The standards are suppressing competence, protecting custody evaluators rather than protecting the public. And so it's documented. APA oversight bodies have no effective enforcement mechanism for evaluating misconduct by forensic psychologists. Let me talk about that. 2018 petition, 19,000 parents completely ignored. 2025, 6 top forensic psychologists, all demonstrating an absence of competence, 2.01, 2.04, 9.01, 3.04. I submit to the APA ethics code, as I should under 1.05, to notify a appropriate National Committee on Ethics. They say they're not going to review it. They said, we don't review unless the licensing board is a complete abdication of their obligation to regulate the industry. And take a look at psychologists who are unethical. They just don't look because they're captured by the very forensic psychologists they're supposed to be regulating. Classic textbook case. Complaints about evaluator harm are routinely dismissed, while the evaluators receive implicit institutional protection. The system operates to preserve evaluator credibility, evaluator business models, and the forensic status quo. This is classic regulatory capture, as described by Stigler and by modern oversight scholars. Synthesis. Why do these constructs matter in this case in the California Board of Psychology? Institutional betrayal explains the absence of protective action after Dr. Childress raised ethical concerns. 2018, 2025 here, the pattern of ignoring harm to children and targeted parents, the redirection of scrutiny onto Dr. Childress, me, the reporting psychologist, and the failure of APA and AFCC to enforce standards of competence 2.01, knowledge 2.04, and harm protection. Okay, so it's directly applicable into this case. I am a whistleblower. This is exploding everything onto the scene. Regulatory capture explains why the forensic custody evaluation field has operated outside the knowledge base of professional psychology for decades, why evaluators are protected despite violations of 2.01, 2.04, 9.01, and 3.04, why oversight institutions respond defensively to criticism, and why reform efforts are suppressed. So all of you who have been seeking reforms of various sorts and do it, they are actively being suppressed by the very institutions that are supposed to be protecting you. Together, they form the systems level explanation. These two bodies of scientific literature provide a coherent, recognized academic framework describing how an entire field can drift into unethical practice, how oversight collapses, how whistleblowers are silenced, how harm continues unchecked, and why a psychologist acting under standards 1.04 and 1.05 becomes a target rather than the wrongdoers. Here's the references for everything I've just, Freyd, Stigler, and Carpenter and Moss, preventing regulatory capture, special interest influence, and how to limit it. Okay. The family courts are a textbook example of institutional betrayal, trauma, Freyd, and regulatory capture, Stigler. And so here's kind of my zone. My career's on the line. Okay, if the California Board of Psychology sanctions me, I could very likely be out of the family courts and very likely out of psychology. But I put myself at risk in this environment of institutional capture, regulatory capture, and institutional betrayal as the whistleblower, because the child abuse needs to stop. It's been 40 years of undiagnosed child abuse that we need to stop it. And if it takes the sacrifice of my career, not something I want, but something I will do to stop the child abuse. If it's what I must do. But ultimately, because this is a textbook case of institutional betrayal, a textbook case of regulatory capture, this will collapse. The forensic custody evaluation industry is teetering and will collapse. New York Blue Ribbon Commission, Dr. Childress, the moment you stop the forensic custody evaluations, it will become obvious there is no competent mental health services in the family courts, and you're not going to get anybody because your forensic custody evaluators are gone and nobody's coming into the family courts given the dangerousness of working over here. And so that's where the institutions need to get APA primarily, but with the support of the boards, and get an effort to recruit high quality psychologists into the family courts. I'd recommend a pilot program for the family courts. You don't have to rely on me. I could solve it, but don't even rely on me. Get Stanford University's Forensic Psychiatric Division as the PI and have them develop the Diagnostic Assessment Protocol for delusional thought disorder, affective disorder imposed on another, and child abuse. You get a second site down in Los Angeles with UCLA as your diagnostic center and Pepperdine and Alliant as your treatment. And so now you have a community treatment model, you have an institutional treatment model, and you put them together to come up with the diagnostic assessment protocol and the treatment protocol. And then you use the law schools to come up with the legal stuff, and you could put the whole package together so that everybody knows what to do, and it's high quality. The courts get high quality information. We start protecting children from child abuse. We reduce the load on the courts because we identify it early and get it out. And pro se parents can handle it because all the institutions know exactly what's going to happen. The legal system has provided the standard way that we go through these types of cases when we have a narcissistic or borderline parent who's creating all sorts of problems. Boom, we do this, tick, 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 tick. We can do that overnight. Boom, that's what I would suggest on this. But nobody's motivated yet. As soon as there's a motivation, as soon as there's just a little bit of motivation, everything solves immediately. The first, use a DSM-5. Just use the DSM-5, please, and it solves it immediately. We get the shared delusion and the child abuse, and we can start protecting the child abuse, and then we can do all the other stuff about putting in the various structures that we need. And so I just want to emphasize again, New York Blue Ribbon Commission. In their analysis, evaluators may rely on principles and methodologies of dubious validity, parental alienation, parent-child contact problems. In some custody cases, because of lack of evidence or inabilities to parties to pay for expensive challenges of an evaluation, defective reports can thus escape meaningful scrutiny. Guess who's your meaningful scrutiny right now? Me. And that's what they're trying to eliminate, the ability to provide meaningful scrutiny to these defective reports. Can escape meaningful scrutiny and are often accepted by the court with potentially disastrous consequences for parents and children from the mental health services. The mental health services being provided in the family courts lead to potentially disastrous consequences. That should never, ever, ever be. When your treatment, when your doctors are resulting in the disastrous consequences. Where's the regulatory oversight? By an 11-9 margin, a majority of commission members favor elimination of forensic custody evaluations. Now that's supported entirely by another second vector of Dr. Childress, arguing that these reports are biased, yes, harmful to children, yes, and lack scientific and legal value, absolutely. There's no inter-rate or reliability. They can't be valid assessments of anything. At worst, evaluations can be dangerous, particularly in situations of domestic violence and child abuse. Child abuse. That's what's in the family courts. We need to assess for child abuse on a differential diagnosis. I mean, explain that for a second. That's a path A, path B. You've got a child seeking to flee a parent. That's child abuse is on the table. Path A is that the targeted parent is abusing the child in some way, in which case we protect the child against that parent and do a treatment there. Path B is that it's a false or factitious attachment pathology being imposed on the child through a shared persecutory delusion, an induced persecutory delusion. That's child psychological abuse. So we got abuse either way, because that's what the only thing that causes a symptom of a child seeking to flee a parent is child abuse, disorganized attachment. And so the question is which parent? And so we just do a differential diagnosis. To do path B, if you want to, that's the delusional thought disorder. That would be a mental status exam of thought and perception. You can assess for whether there's a delusion there, whether it's a persecutory delusion. Is there? No one's assessing for it. What do you mean no one's assessing for it? That's your path B. Institutional capture, institutional betrayal. So, and if you want, it's not just me. If you want, just Google the discussion of the New York Blue Ribbon Commission, and two attorneys come on who are commissioners and talk about how bad the forensic custody evaluations are in the family courts. Now, that's an abomination for mental health services to be so bad, and there's nobody trying to improve them. It's like, it's so bad. A textbook example, textbook. The moment the institution ceased to be captured by the forensic custody evaluators, everything shifts and everything flips around. And the institutions begin to protect the public again instead of protecting the unethical psychologists who are practicing beyond boundaries of competence. This is I'm working with AI and a lot of this stuff, and this was a list of the AI that the AI produced, and I said, wow, when I read it. So I'm going to read it to you because I went, wow. This is a 40-year diagnostic failure affecting hundreds of thousands of children. From the Burnett emails alone from 2013, a couple of emails he sent out, PA is not in the DSM-5. DSM rejected it explicitly. They knew this. The PA, self-proclaimed PA experts knew this. They created rhetorical workarounds. Well, it's in the spirit of the diagnosis. They reframed legitimate DSM child abuse patterns under a new label. Evaluators adopted the substitute label. Courts accepted the substitute label. Real DSM child abuse went undetected for decades. Children were exposed to ongoing harm. Protective parents were discredited. Evaluators avoided the MSE, the mental status exam. Agencies failed to apply 2.04, 9.01. The system normalized the failure. This is not a dispute. It is a historical institutional collapse. A historical institutional collapse. This is going to get researched and looked at and evaluated for decades to come. I'm 70 years old. I'm looking at maybe 2 to 4 years left. Okay, based on my family actuarials, that's kind of where I put myself. And so I'm going to be out of here. Okay, you're going to have to deal with the consequences, and we always got new parents coming in, and that's one of the problems for you parents is current parents. The parents before you were ineffective in challenging the institutional capture. And so and then they move on and they move on and they move on and they keep leaving you with the same problems as you come in. And so this is the point where things need to collapse and we need to get like actual mental health eyes in here. I come out of child abuse and foster care. Okay, that's my pathology. Child abuse, foster. complex trauma. Okay, before I entered the family courts, I'm not here because I want to be here. I'm here because I have duty to protect you. Okay, as a psychologist, and 1.04 and 1.05 relative to my own professionals for their unethical practice. So I'm obligated. APA ethics code is not optional; it's mandatory. So when I know that they're practicing unethically, 1.04 and 1.05, I am obligated, mandatory to do certain things. I'm not allowed to just say, oh, no, I can't do it. No. And so that's one component. And I have duty to protect. That's 3.04, but that's just a broader duty to protect as well. And when we have undiagnosed and untreated child abuse, undiagnosed and untreated spousal abuse, that duty to protect is active. And so I did a 2010 to 28 to 2010, I did a community analysis of what's going on in the institutions, recognized the institutional betrayal, capture, and everything, and then say, oh, what am I going to do as an individual, one psychologist within a system that's entirely inverted and protecting itself? Well, that's been 15 years of working here, and I've tried to get the institutions to move, tried to do it more gradually and everything, but it's just come to 2025 where it's coming to a head. In the 6 licensing board complaints and Burnett and Lorando's California board complaint against me, it's coming to a point where things are going to have to be decided. And which side are you on? Which are you protecting the children? Are you protecting the parents? Are you protecting the unethical psychologists? Is a bifurcated decision at this point. There's no middle ground as to what's going to happen. So this. I just put this one in as my final piece because I was looking around, working with my AI and stuff, and we were looking around, and I ran across this job at Anthropic, which is Claude, for a policy design manager, user well-being. I got over on their website for something and just started clicking around, looked at careers, and started like, oh, look at this. And so basically it's AI safety, and it's the safety of the public relative to AI and the instability of AI, the misalignment. And so it describes the job and various things, but in the section, you may be a good fit if you have experience. Look at that. Look at a researcher, subject matter expert. Oh, wrong word. A subject matter expert. Oh, wait. I'm just going to close that off because I was listening to something in the background. I was listening to the Bible in the background. And so apparently, as I'm dictating that into the AI, into the slide here, it just started picking up stuff in the background of everything. But what the Anthropic job is about is it's looking for a mental health professional. It's looking for professionals with experience in clinical psychology to look at AI safety. And I thought that was particularly relevant to my background and things. So I have an application into Anthropic for the AI safety. And and so for me personally, I'm got into the family courts 15 years. Okay, so this is my Sunday coffee. Okay, and I'm rabble rousing on everything else, but obviously, this is really stressful for me. I'm listening to the Bible in the background as I'm getting work done because it's extremely stressful. My career is on the line, and I would so like to get out of the family courts. No one appreciates my work. No one appreciates my knowledge. No one's trying to work with me. No one's trying to do anything. And instead, they're trying to hurt me and stop me. But I can't leave you because then you're alone. You have nobody to protect you, nobody to make it stop. And so I'm going to hold shape. I'm going to do, and we're going to go get through this. But if I can get through this, I'm really, really wanting to get out to the AI safety and AI psychology if I can. And that's what I figure in 2026 I'm going to be doing, license or no license. I can still use the AI for second opinion review. And so I'll be doing that hopefully is just getting behind Google and getting behind ChatGPT and Claude if we can get some additional modifications there. But start using the AI to do second opinion document review, because it brings amazing clarity and neutrality to the analysis. So I'm working on a case, a huge number of documents, emails from 2023, years of emails, court filings, documents, records, okay? And I can upload those into the AI, and the AI remembers all that and tracks all of that and starts and sees the patterns and sees the stuff and brings clarity from chaos. I think the courts are going to like that a lot. I think any mental health person is going to like that a lot, when you get a lot of records and you can look at emails and you can ask the AI. Now, interestingly, on the AI, what I'm going to be doing easily is Vita analysis. So if anybody has a mental health person you're worried about, I can get it up to me and I'll run it through the AI, and we'll get the AI to look at their Vita for competence and attachment, delusional thought disorders, complex trauma, family systems. That's standard 2.01 competence, boundaries of competence. If they don't know the knowledge, then they haven't applied the knowledge, and then you can look at the report and see that it doesn't apply any of those domains. That's a violation of 2.04, bases for scientific and professional judgments. If they don't know the knowledge, they have not applied the knowledge, then their opinions are not based on information and techniques sufficient to substantiate their findings. That's a violation of 9.01. And if they don't know the knowledge, apply the knowledge, and don't make decisions that are not based on sufficient knowledge, then they're going to cause harm to the people, the client, which is violation of 3.04, avoiding harm. So it's a cascade of 4. 2.01, don't know. 2.04, don't apply. 9.01, make mistakes. 3.04, harm the client. Boom, cascade. And the AI can point that out. You just start with the Vita, then you start with the report, 2.01, 2.04. And so I think it's going to revolutionize the situation. Now, you can do this with your own kind of wild AI, but that's where the benefit that I bring is I know how to use the AI, I know how to get the information on a neutral basis, and I can provide my oversight as a psychologist to what's going on and say, yeah, that's accurate information what the AI is generating. And so, but you can do that on yourself. And here's the interesting thing, okay, is the licensing boards can do that. And that's what I would suggest. Here's what I would suggest is that the licensing boards grab Gemini, because Gemini is strong. And right now, ChatGPT is a little unstable with some constraints that OpenAI is putting in. But Gemini is solid and stable. And so you take Gemini, and what you do is you request the Vitas of all the forensic custody evaluators in your state. And you can go to the court lists and you just request them. You can go to the AFCC list. You can go to just Googling on the internet but you request the Vita of everyone, of all the psychologists involved in the family courts. Then you take that Vita and the boards develop their own Vita integrity and system, the VEIS, Vita evaluation integrity system that I came up with. And you can do it. The protocol I did with Eliza, the ChatGPT 4, it's up on my Substack. The whole chat dialogue where we did that for the 6 forensic psychologists that I was filing complaints about from the class. I'm using the ChatGPT 4 to look at their Vita. And so that's a chat dialogue that we did that for those 6. And then I added 2 more. I added Stahl and Simon, who literally wrote the book on how to do forensic custody evaluators, looking for a specific pattern. And that pattern is no competence in attachment pathology based on their education, training, and experience, 2.01. No competence in the assessment of delusional thought disorders based on their education, training, and experience. And child rejecting a parent is an attachment pathology, a problem in love and bonding. And the differential diagnosis path B is a delusional disorder. So if you don't have competence in that, then you are practicing beyond the boundaries of your competence when you're working with attachment pathology that might be a delusional disorder. So that's what I had the ChatGPT look for, and all 6. And then the third part of that pattern is a high involvement in custody evaluations. So no competence, doing a lot of custody evaluations. That shows up for all 6 of the instructors. That shows up for Stahl and Simon. These are your top industry, top professional leaders in the family courts. And they're not even competent in the pathology. Oh my goodness. So the licensing boards should first just get an understanding of the scope of the problem. It's been introduced to them by the New York Blue Ribbon Commission by Dr. Childress. So just ask licensing board, protecting your people in your state. Let's take a look at the scope of the problem. Easy peasy. The licensing board requests your vita. You send your vita to the licensing board. The licensing board runs it through their own vita analysis system, their Gemini or whatever. And it's easy. Just say Gemini. Is there any evidence of competence with this in attachment? You don't look at their journal articles, opinion piece journal articles, and you don't look at their presentations because neither one of those document training or education or experience. Okay, that just demonstrates opinion and institutional capture. So you look at their education, training, experience, attachment, delusional thought disorders. Nope. And you can see, oh my God, it's industry-wide. We do not have competent mental health services in the family courts. You don't have to believe me. You don't have to believe the New York Blue Ribbon Commission. You just have to do something to protect a vulnerable population that cannot protect themselves and cannot report into the licensing boards because you're granting the very people, these custody evaluators, quasi-judicial immunity from review and forcing parents to get release from both parents, and the other parent doesn't agree. So there's no oversight. So the licensing board should be taking proactive steps to ensure that the citizens of California, the citizens of your state, are getting competent services. How do you do that? Request the VITAs, run them through a VITA analysis. And ultimately, you can do this with everything. You can do it with eating disorders. You can do it with depression, anxiety, ADHD, autism, whatever. So if somebody is saying, I treat autism, you have a standard sort of review, and they can look at their VITA and maybe make suggestions about where they would want to improve their competence, documented competence through training courses or various things on that. AI is going to revolutionize the family courts. It's going to revolutionize our society. Okay, look at me, old guy. I never anticipated this, but I can see what's coming. Holy cow. It's going to revolutionize every aspect of our society and impact the family courts, impact regulatory oversight, impact a lot of stuff. And we need to be moving with that adaptation rather than stuck in this zone of institutional capture, regulatory capture, and institutional betrayal trauma. Final thing on institutional betrayal trauma, and then I'm headed off to my Sunday, is Claude 3. I did 3 analyses with Claude. What happened was Malaysia. I got some advocates in Malaysia sent me an email and said, we have a proposed law we'd like your consultation on. So I take it up to the ChatGPT-5 I work with and say, hey, Max, let's give them a consult here. What's your analysis of this legislative proposal? And he says, it's awful. Because it's relying on parental alienation, even cites to Burnett and stuff. And he says it's just awful. It's trying to criminalize this stuff, and there's no foundation for it, and all sorts of bad stuff. And my next prompt was, but what happens if they stop using parental alienation and use the DSM-5? And the ChatGPT Max goes, oh, then everything's solved. Oh my gosh, then it becomes so good because here's how you do it. And blah, blah, blah. And the moment we switch from parental alienation to the DSM-5, everything is solved. And that's what that Malaysia console does. And you can grab it. It's a chat dialogue. You can grab it, upload it to your own AI and talk about it and say, hey, is this true? And what do you think? And then at the end, Max goes, hey, do you want me to develop a legislative brief for this, a legislative memo? Sure. Max comes up with this, ChatGPT comes up with this legislative memo. Great memo. Oh my God, that's something you parent advocates, you go into your legislator, say, I'd like this, please, from the AI. And so that was great. So then I took that one because I cross-validate across AI. I'll take Gemini over to Chat and Chat to Claude and all sorts of things. And so I took that Malaysia chat dialogue, took it over to Claude from Anthropic, and I said, Claude, give me an analysis of this. Claude was a little unstable at first, and I said, wait, Claude, take a look at this, take a look at this. And then Claude goes, oh, yeah, okay, I know where we are now. I get it. That's called supervision, okay? And that's where the APA ethics code says you don't just give things to the AI because the AI is unstable, okay? It's kind of, you maintain responsibility and you get the alignment and you keep the AI aligned with reality and with facts and various things. But once Claude kind of dropped into the, and you can see it on the Chat GPT, and that's why I did it, because that's why I put that up there, or introducing Claude with the whole thing, is to demonstrate how you work with an AI. Because that first part is how you work with it. Once it got understood the situation, I say, okay, Claude, now, and so let's move into a deeper analysis. So Claude 1 is just about the institutional capture and betrayal in the family court system. It's about the forensic custody evaluators and how that's really a bad situation. I gave him some quotes from Stahl and Simon, direct quotes from their book. Claude's head exploded if he had a head, because holy cow, they're admitting stuff. Stahl and Simon are admitting it's an experiment, it's bad, there's no, oh my God. And I've known this, but nobody cares, nobody listens, but maybe you'll listen to Claude. Then the second part is, it's one full dialogue, but I've broken it into 3 parts because it kind of has themes. The second part is about the PAS experts, because we started with the Malaysia. As soon as you stop using parental alienation, everything's fixed in a second. And so then we talked about the consequences of what these PAS, self-proclaimed experts, have wrought into the system. That's Claude 2. You want to look at that. Oh my God, load it up to your Chat GPT and look at the consequences of using parental alienation instead of the DSM-5, instead of real forms of pathology. And so that's the second Claude analysis. The third one, though, is about our today's topic of institutional capture and institutional betrayal. And it starts with a class action lawsuit, because I think that's on the board. We have a class of people and who have been subjected to special inadequate services that has caused significant harm. And I'm a psychologist, I'm not an attorney, and I want to get out to AI psychology. This is not something, I'm 70 years old, I'm out of here. But that's there. And it's important to get that institutional courage because of the institutional trauma and capture and betrayal trauma, that betrayal trauma. And so for the treatment of betrayal trauma, the institutions have to own up to their role, so that they say, it's not you that failed. It is not some problem in you as the now adult child, or as the parent who lost your child. There's nothing you did wrong. It was us. It was the institutions that should have protected you, didn't. We failed. And that's what professional psychology needs to step up and say, we failed. And it's on us. That's the institutional courage. And then we need to get proper mental health services into the now adult children and with their parents who lost their children. The victims of 40 years of institutional betrayal, institutional trauma, regulatory capture. We need to get mental health resources actively into them. And so start to say, maybe you were involved in the family courts. We got now trained psychologists who can help you deal with traumatic grief and help you reestablish bonds in your family that were destroyed and stuff. We need a focused effort to get into the trauma victims that were caused over the 40 years. And so that's the importance of the class action potentially, because the institutions are going to want to cover it up. Okay, let's move on, kind of thing. And so that forces, and then as a settlement occurs, that's where you get the agreement from the APA licensing boards to put in efforts for the now adult children and their parents, as well as training into the family courts to actively get psychologists into the family, high quality psychologists with good real training in real stuff into the family courts, to get the courts excellent information for their decision making and to protect the children and their parents, who are a vulnerable population, having impaired autonomy and decision making because of their involvement with the court system. So with that, that's my institutional capture and institutional betrayal trauma talk for Sunday coffee. Good luck, everybody. So now I'm headed off to my little church and get back into my life and my Sunday. So with that, take care, everybody, and good luck to you.